Welcome to the virtual hearing for the inquiry of the impact of technological and other change on the future of work and workers in New South Wales. Before I commence, I would like to acknowledge the Gadigal people who are the traditional custodians of the land on which the Parliament sits. I would also like to pay respects to elders past, present and emerging of the Eora Nation and extend that respect to all First Nations people who are present or who are watching. Today's hearing is being conducted as a fully virtual hearing. This enables the work of the committee to continue during the COVID-19 pandemic without compromising the health and safety of members, witnesses and staff. As we break new ground with the technology, I would ask for everyone's patience through any technical difficulties we may encounter today. If participants lose their internet connection and are disconnected from the virtual hearing, they are asked to rejoin the hearing by using the same link as provided by the Committee Secretariat. Today, we will be hearing evidence from the Point-to-Point Transport Commissioner, as well as the Chief Commissioner and Commissioner of State Revenue. Before we commence, I would like to make some brief comments about the procedures for today's hearings. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the virtual public hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry's terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions a witness could only answer if they had more time or with certain documents to hand. In those circumstances, witnesses are advised that they can take a question or notice and provide an answer within 21 days. Today's proceedings are being broadcast live and the video recording will be available on YouTube afterwards. Also, a transcript will be placed on the committee's website once it becomes available. Finally, a few notes on virtual hearing etiquette to minimise disruptions and assist our Hansard reporters. Can I ask committee members to clearly identify who questions are directed to, and can I ask everyone to please state their name when they begin speaking? Could everybody please mute their microphones when they're not speaking? Please remember to turn your microphones back on when you're getting ready to speak. If you start speaking whilst muted, please state your question or answer again so it can be recorded in the transcript. Members and witnesses should avoid speaking over each other so that all can be heard clearly. Also, to assist Hansard, may I remind members and witnesses to speak directly into the microphone and avoid making comments when your head is turned away. I now welcome our first witness. First Commissioner, could you please state your full name and position title, and I swear either an oath or affirmation from the cards that have been emailed to you by the Secretariat.
Thank you, Chair. Anthony Wing, New South Wales Point-to-Point Transport Commissioner. I swear to tell the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Commissioner. Commissioner, would you like to start by making an opening statement?
Yes, thank you, Chair. I'll just briefly outline my role and some of our recent achievements over the last year. I was appointed as Point-to-Point Transport Commissioner on the 1st of July 2019. As the regulator for the point-to-point industry, I'm responsible for authorising service providers, issuing taxi licenses, managing compliance and enforcement, and making recommendations for passenger and driver safety in New South Wales. So what is point-to-point transport? In New South Wales, point-to-point transport is any commercial passenger service in a vehicle other than a bus. For example, taxis, hire vehicles and rideshare services. Point-to-point is about passenger services. It does not cover delivery services. It also does not cover workplace arrangements. With regard to my compliance approach, it's my priority, regardless of a business's size or their service delivery model. I apply the law to all service providers, large or small. I expect all service providers to make sure they are effectively managing and improving the safety of their services in a practical way. Audits are one of the means we use to oversight industry. Safety audits, along with targeted campaigns, on-street compliance, advisory visits, investigations and enforcement, are key to ensuring the point-to-point transport industry is safe for both drivers and passengers. During audits, my team assessed the service providers' compliance with our laws, as well as their identification of risks to safety and implementation of appropriate control measures. Compliance actions are taken as appropriate, which may include issuing warning letters, improvement notices, prohibition notices or penalty notices. I also publicise safety messages to the broader industry, drawn from compliance activities. However, there are statutory limitations in point-to-point transport legislation on my ability to disclose information such as an audit report itself. One of the key reasons these limitations were incorporated into legislation is to prevent disclosure of information, such as audit reports, that could prejudice the Commissioner's ability to perform their functions or undermine current and future investigative processes. And finally, with regard to the extent of the Commission's achievements in the last year, so during the 12 months to 30 June 2021, in addition to all the additional work we've had to do as a result of COVID, my compliance officers carried out 61 safety audits and 78 advisory visits, 1,349 taxi vehicle compliance checks, and 1,736 hire vehicle and rideshare compliance checks. And they issued 184 improvement notices and 25 prohibition notices. A further 1,194 penalty infringements were issued by my authorised officers and New South Wales Police for individual breaches of the point-to-point transport law. Thank you, Chair, and to the committee.
Thank you, Commissioner. I might kick off with just some questions arising from your opening statement. How many audits did you do again, did you say? Over what period of time?
This is the last financial year, so the 12 months to 30 June was 61 safety audits and 78 advisory visits.
Okay, and of them, how many of them are you able to give us a breakdown between rideshare and taxis in that respect?
I don't have an exact breakdown, but I could get you a breakdown between taxi service providers and booking service providers. Rideshare, as you know, is not defined in our Act, but yes, I could get you a breakdown between taxi and booking service providers.
That would be very helpful, Commissioner, if you could as well. What were the results of these audits?
The results of the audits. So one of the things we do, well, the way an audit works is we are looking at compliance with the obligations that are placed on service providers under the Act, and I'm happy to go through those at some point if helpful. We are also looking at whether they have identified risks properly and whether they have controls in place. Of those safety audits and from our work, we issued 184 improvement notices during the year. Generally, we consider that people needed to take steps to improve the effectiveness of controls around their around some of the risks that were identified.
And did that lead to you issuing, do you have a form of prohibition notice or anything like akin to a prohibition notice, Commissioner?
We have a prohibition notice, yes. So the improvement notices are generally issued where there is an improvement that needs to be made to some safety measure. And they are generally given a period of time to do it within. A prohibition notice is issued where there is an immediate, well, the authorised officer thinks that there is an immediate risk to health and safety and that something needs to not happen immediately or until something is dealt with. That need not require any improvements to the system. Sometimes it might be something completely extraneous, but that also exists, and those notices can be issued, and 25 of those were issued in the last financial year.
Okay, and have you commenced any prosecutions?
Yes, we've prosecuted, I think we've run about 10 prosecutions since I commenced. Prosecutions are initiated either whether the facts warrant it or where there may not be other alternative means such as penalty notices, or perhaps penalty notices have not been effective.
Have any of those prosecutions been about, I guess, organisations that might be relevant to our terms of reference? I could give you a couple of examples if that's helpful, and then I guess you could decide. Well, specifically, have you launched any prosecutions against Uber, Didi, Ola, I guess, are the ones that would be the ones we would be most of interest to us?
We have most recently, I think this was just I recently prosecuted a couple of affiliate taxi providers for breach of safety duties under the law, and they were issued significant fines by the court. But otherwise, I would say the most likely thing is not the service providers, but we've also used prosecutions to crack down on certain activities where fines weren't working, but which would have involved rideshare as well as hire car drivers. For example,
but we're talking about specifically the platforms, independent of people who are providing services through the platforms.
Okay, well, in that case, no, we have not issued prosecutions against Uber, Didi, or Ola. No.
Okay. On notice, do you mind providing us just a list of the court cases that you've brought and when they were settled?
I'm happy to do that. Probably on the website, I'm happy to do that.
Can I just turn now specifically to a press release that you issued on the 12th of August 2021? Did you issue Uber with 13 improvement notices and over $200,000 in fines as a result of a recent safety audit?
Yes, that's right.
And when did you commence that audit into Uber?
At this point, we did a bit over a year ago, and it ran for about a year. And we determined at the outset that we wanted to do a thorough and full audit of their systems, and to make sure that we fully understood their systems and whether they were effective in doing what they said they were going to do. Probably took a little bit longer than would have in a non-COVID era, because there were periods where we simply couldn't interact. But yes, that was the period of the audit.
And did one of the areas of concerns you found include the failure of Uber to report a number of notifiable occurrences to you as soon as practical?
When we audited, we found a number of areas that, well, as I think we said in our press release, while they do have extensive safety systems, they need to be fully effective in doing what they say they're doing. One of the areas where we had concerns was that we found that they did not appear to be reporting all notifiable occurrences. Notifiable occurrences are those matters, certain matters that need to be reported to the regulator, as well as being addressed by the service provider. Found that they were not identifying all notifiable occurrences. They then did a backward analysis and reported a whole lot of extra notifiable occurrences that had not been reported. So they reported them, but at that point they were quite late, and we issued them fines, as well as giving them a future direction to fix their notifiable occurrence reporting system.
What were the nature of the incidents that they didn't report to you?
Well, there's a number of categories of incidents that need to be reported to us. So while the majority of them were minor traffic incidents, for example, or they may have been things such as rear end collisions, which may not have been the fault of the driver, but they should still be reported because they are a mechanical issue. There were also within there some others which were, I guess we categorized them as ones we more would immediately wanted to have looked at, which is one of the reasons for issuing with fines for being late in reporting them. And that includes matters such as serious mechanical failures in vehicles and incidents which have been reported to police. So
I'm about to go to my colleagues, but Commissioner, did Uber fail to report to you sexual assaults?
I would be very careful because they're all alleged, of course. But
alleged sexual assaults?
They failed to report to us certain matters which had been reported to police, which would fall under the category of sexual misconduct.
And how many of those incidents are we talking about?
There were about, I think there were 12 that could be categorized as sexual misconduct, which were reported to police, which were not reported to us in time.
Over 1 year? Or 18 months?
That went backwards. That went backwards about 18 months, yes.
So 12 over 18 months were not reported to you?
I would have to find the exact time for which their analysis went, but yes, that would be the case.
Did you ascertain whether or not they were reported to the police proximate to the time where the alleged assaults took place?
Well, one of the concerns we have for late reporting here is, of course, that makes it more difficult for us to follow up with police to assure that proper action has been taken. That's the difficulty we face, of course. That's one of the reasons for requiring notifiable occurrences to be made in a reasonable amount of time, and why for those ones it seemed appropriate that they should be fined for not making them in a reasonable amount of time.
Did you find equal levels of non-reporting from any other platform, independent of the drivers?
We haven't found anyone else for that level, for non-reporting of this nature to that extent. That's not to say I don't want to make any comments which ever say that anyone has or hasn't done anything, but
Sure, but you haven't found anyone else for the same.
We've issued other fines for not reporting notifiable occurrences, but these are the largest level of fines, yes.
All right, I'll go to Mr. Shoebridge.
Thanks very much, Commissioner. What was the longest delay of those type of failures the Chair was asking about from Uber, in terms of reporting to you that a notifiable matter had occurred which should have been reported to police? What was the longest delay from Uber?
I don't have an exact time, but let us say it could have been in the order of 1.5 years.
1.5 years.
If they failed to identify them in the first place and then pick them up later, those would have been the case, yes.
Okay. Well, could you provide us some more detail on notice about those?
Yes, of course.
Thanks. Could I turn to the passenger service levy? How much has been collected in total in the passenger service levy so far?
Just allow me to. Right, so up till 30 June, which up to 30 June, it was $210 million, $755,383.
And in the period from June to now, do you have any update?
No, Revenue New South Wales won't yet have published that quarter's figures.
Yeah. And sorry, could you remind me again, up to the 30th of June, was
210,755,000.
What's happened to that $210 million?
It will have been remitted to Treasury to hold on account.
Well, it's just gone to Treasury, so it's sitting in Treasury. Has it gone to anybody who's suffered financially as a result of the changes?
Right. So it was raised to cover the costs of providing industry assistance for taxi, well, primarily for taxi licensees. The assistance was paid out by the Policy Department, Transport for New South Wales. So I could only give you a high-level overview of it, but they paid out a significant amount as a result of a assistance package following the first stage of reforms, and the government has recently announced that there will be a further assistance package, but they haven't, and I'm not privy to the amount.
Well, do you know how much has been paid out so far in industry assistance?
Can I get onto the Policy Department and get back to you on that?
All right, thanks, Commissioner. What is the anticipated revenue for the passenger service levy this year? I mean, this is an amount that's, I'll just finish there. What's the anticipated revenue for this year?
I may have some figures for the revenue for last year, although I would point out that it's likely to be a lot stronger this year, assuming we don't have any further COVID lockdown evidence. In the last, 2020-21 year, $52.63 million was collected, but I'm not sure that you could use that as an anticipated measure for this year, given that it's a long period when the industry couldn't operate.
So the 210 million had been the accumulated payment all the way up to the end of last year for a number of years. Is that right?
Yes, that's right.
And last year was in the order of $56 million.
I think 52.6.
$52 million. So can you tell me what the budgeted revenue is for this year? You're not able to do that?
I don't have that figure off the top of my head. I'd have to check Treasury papers.
Could you provide it on notice?
Yes, of course.
And particularly if there'd been an update, given the rather tempestuous year that we've had. Could you provide that rather than just the budget paper figure?
Any update? Yes, obviously it's a very difficult thing to do, given the last year was so difficult for the industry.
Has Uber fully complied with its obligations for payments of the passenger service levy?
Yes, they have.
How much has Uber paid?
I can tell you they're the most significant taxpayer. I'm bound by secrecy laws under the Tax Administration Act, which is not actually my act, but I'm not able to divulge individual taxpayers' payments.
Well, again, I'm now going to ask you if you could, I'm going to press it. Will you please provide us with the amount that Uber has paid for the passenger service levy? Mr. Wing, Commissioner, I'm happy if you take that on notice and seek some advice on it. The conflict between your obligation to provide answers to Parliament and your purported secrecy obligations under the Tax Act. Did you want to take that on notice?
Mr. Schubert, I'm happy to take that on notice. As you'll appreciate, I would need legal advice on that.
Chair, yeah,
Yep,
Chair, I'll take a
comfortable
point
with
of order on that. I think that
Point.
it's appropriate that if the Pointtopoint Commissioner has concerns about the legalities, that he be given the opportunity to seek advice and then provide.
That just happened, Wes. That's all just happened. That's
I'm
what just
making
happened.
sure that you know.
You're just describing what happened, Wes.
I will just rule
the
the matter that the Commissioner has sought advice as a result of the Commissioner making the decision to sort advice. We do not have to have a complicated question about whether or not the Parliamentary Evidence Act overrides secrecy. So we'll allow Mr. Shubish to move on.
All right. Are there any? I note that you conducted a number of audits of compliance with the passenger service levy. Can you provide details about what happened on those audits, Commissioner?
Yes, we also read audits service providers to look at their returns and make sure that they are making the appropriate returns and paying the levy. There have been cases where we have, as a result of those audits, revised the amount that service providers have to pay, and that is a continual oversight process.
Well, when you say revised, let's try and remove as many euphemisms as we can. You did a bunch of audits. There was significant non-compliance. There was underpayment, and you required the underpayments to be rectified. Would that be a less euphemistic description of what happened, Commissioner?
I wouldn't say there was significant and widespread undercompliance, but the rest of it I would agree with, yes.
Well, I didn't say significant and widespread either. I just said significant. So would that be right?
Well, I'm saying that where we found we did audits. In some cases, we found that companies needed to pay more, or service providers needed to pay more, and yes, we told them to rectify that and rectify.
Well, what was the scale of the underpayments that you discovered, or the average from your audits?
I don't have an average. The largest would have been in the order of $200,000 over some period of time. Others might have been a few thousand. Some people were paying too much.
You see, an underpayment of $200,000 is a failure to disclose 200,000 trips, isn't it?
Yes, essentially, that was yes, exactly right.
That's a bloody big non-disclosure. Would that be a fair summary of it? And if you don't like my description of a bloody big non-disclosure, how would you describe it?
I would say it's the amount that we told them they needed to pay. Yes.
Failing to disclose 200,000 passenger trips, that would be hard. I can't conceive of how that could be accidental. Are you saying it was accidental and excusable?
Those are two different words. So in this case, what happened?
How would you describe an entity failing to disclose 200,000 passenger trips to you? How would you describe it?
So in that case, what had happened was the entity had purchased software from another provider to help them run their passenger service levy. And it appeared that the people that they had doing it had in fact not fully understand how to use this software. And so they simply failed to provide a whole lot of evidence, so a whole lot of data. So we went back to them and said, when we've gone through it, one, you need to fix your ability to use the software, which they have done, And 2, you have back payments due.
Who was it?
I suppose in this case, it was a large taxi company.
Who was it?
Okay, well, I think I can probably disclose that. So it was GM Cabs, which had been making underpayments.
And did they explain to you how it was that they had had such a comprehensive failure?
Well, when my auditors looked at it, it seemed, and based on discussion with them and also looking at it, that their people in charge of making the reporting had simply not understood the software that they had purchased from someone else.
What proportion of the trips was it that had been failed to be disclosed? They'd failed to disclose 200,000 in that same reporting period. How many had they actually undertaken?
Well, now we're back into the taxation secrecy provisions. Do you want me to take that on?
Press for an answer, Commissioner, and you may want to take it on notice again.
I will take that one on notice as well.
And Commissioner, finally, can you give us a list of the audits you had and the results of the audits, including the scale of the non-compliance?
The passenger service levy audits.
Correct.
I will take one of those.
Yeah. And lastly, Commissioner, given the scale of non-compliance you found in your 24 audits, can you give us any assurance that there actually is an effective compliance regime in place to ensure this levy is collected?
There is an effective compliance regime in place, and $210 million has been collected already.
Well, you've got one entity that missed 200,000 passenger trips. Apart from random audits, what are you doing to make sure that there's compliance in place?
Well, we do random audits, and as you've seen, that we do random audits, and we also follow up where people have, and this is the most likely area, where people have not been putting in returns or have been putting in returns based on an estimate, which hasn't changed for some time. So, as you've seen, these audits pick up things where there's an issue and back collection occurs.
That concludes this line of questioning, Chair.
Mr. Searle or Mr. Fang? Mr. Searle. Mr. Searle's on mute.
Sorry, Mr. Wing, can you hear me?
I can, thank you.
So tell me, in relation to these audits you've conducted, what sort of policy or process do you undertake to select, for want of a better word, the subjects or targets?
So can I just, for clarification, we're talking about safety audits at this point?
Yes. Well, yeah. But all audits that you are authorised to conduct under your statutory charter. So yes, safety audits, but also the other forms of non-compliance we've been discussing here with you this morning. How would you, do you just accidentally stumble across these in the course of, someone maybe making a complaint to you, or do you actually do proactive audits to make sure that, the regime is being implemented in real life?
Well, we do both. So we have a rolling schedule of audits, which is based on, we have a risk-based analysis of the industry, looking at the various things which might create risks, and we have a rolling schedule of audits based on that. And on top of that, if we receive complaints or we find incidents, or my on-street compliance staff see incidents, that may also bring forward an audit or schedule an audit of that company as well.
Okay. Does your organisation have a policy document or a set of documents that set out how you conduct this and how you select targets or subjects for audits?
We have a risk-based approach. I will have to check whether that's been published on the website or not, but we obviously have.
Commissioner, whether it's been published on the website or not, if your organisation operates subject to written policies, could we see those?
Yes, can I take that on notice?
You certainly may. Absolutely, you may. In relation to prosecutions, again, do you have a prosecution policy? A document that sets out the considerations that you would apply in determining whether or not to actually launch a prosecution or to take some other kind of compliance action?
We do. We have a compliance policy, which I think is published on the website, but I will check that anyway.
Okay.
take into account matters such as the seriousness of the matter, the time since it occurred, whether or not there's a need here for specific or general deterrence to others. We will also take into account a range of other factors.
All right. Well, if it's on the website, obviously you can draw that to our attention. But if it's not, and it is a written policy, I would ask that you share that with the committee if you're able to. And again, I'm happy for you to take that on notice.
Yes, of course.
Mr. Chair, those are my questions.
Mr. Fang, otherwise I'm happy to, or Mr. Mallard or Mr. Pearson, otherwise I'm happy to return to the safety audit. Mr. Fang, you want the call or you want to wait?
If you continue the question.
Right. Thank you. Commissioner, can we just go back to the safety audit into Uber that we were discussing previously? What were the other? We've got the sexual incidents that were not reported, the mechanical incidents not reported. Were there any other incidents not reported? What are the categories of the other incidents that were not reported to you?
There were incidents relating to the incidents. They need to report incidents which are in a number of categories. One of those is mechanical failure, which could be as a result of a minor accident or a major accident, which is causes the vehicle to be unable to travel on. They need to report to us matters that are reported to police. They also need to report to us any incident or accident which results in someone having to attend a hospital. Whether or not they have to stay there, we expect them, if they have to attend a hospital, they need to report them to us as well.
How many of those incidents of people having to attend a hospital were not reported to you?
I don't have exact, a small number, yes.
Small number, what are you talking about?
That number, come back to you.
Sorry, Mr. Wing, your connection just went a bit out there. I missed that.
Oh, I'm sorry. I was saying I don't have an exact number here, but there were a few of them, yes.
10? More than 10?
It may have been around that order of magnitude.
Okay. And did you ever ascertain why Uber wasn't reporting these to you? All these incidents?
Yeah, so as a result of our initial audit, we identified that they seem to have matters that should have been reported in their systems, which had not been reported. And for whatever reason, and it's their job to fix it, but for whatever reason, their systems did not appear to be picking them up. So it may be that they were miscoded by the person who took the report. It may be that their systems simply weren't looking for the right terms, but for whatever reason, that's not a good excuse. And we essentially directed them that they need to work out what's going on and fix it.
Well, in some of the public commentary that surrounded this, it was unclear whether or not these incidents were known to Uber's management and then not reported, or whether they were not known to Uber's management. Were any of these incidents known to Uber's management?
So we don't have any evidence that they were known to Uber's management and deliberately not reported. It would seem far more that their systems were not effective at picking up those incident reports, which should be reported.
Did you check on that specifically as to whether these matters were known to them or not?
Well, we didn't have any evidence that that was the case. All the evidence was that they were simply, the systems were not being effective.
Sure, but did you check?
Well, we would have asked why they weren't reported to us, and my auditors would have looked into the systems to see why they weren't reported to us, and that appears to be the reason.
Can we infer, therefore, that the matters that were reportable to police were unlikely to be reported if they weren't properly picked up by the Uber software or Uber platform?
Well, I think you can infer, in fact, that a number of matters which were reported to police weren't reported to us in a timely manner, and for that reason.
There were matters that were reported to police but were not reported to you?
Well, they had not been reported in a timely manner, and therefore that when they were reported, that was late and they were issued fines as a result.
I appreciate that, Commissioner, but there's an element of, well, I wouldn't say contradiction in what you said, because previously you had said that you weren't sure whether or not it was made aware to management, but if Uber was in a position to provide a report to police, but not to you, the implication would be is that they had some knowledge of it. And
Oh, I see. No, the confusion here is that mostly the complainant to the police would in fact be the person who was the subject of any alleged misconduct. So it might have been the passenger or the driver would make the report to police rather than the company.
have you had any dialogue with the police about whether or not any of these incidences were investigated by them, or?
Where we get a report of a matter that's been reported to police, we follow up with police. Police obviously are investigating the incident itself, but our interest is to know whether the company is appropriately responding or the service provider is appropriately responding. My compliance team will talk to police to get background on the matter. Obviously, one of the reasons why we think it's important that they report them in a timely manner is that we can follow up with police in a timely manner.
Do you have any form of a protocol with New South Wales Police for the exchange of information between the respective agencies?
We have a high-level protocol with police, yes, an MOU.
Okay. On notice, are you able to provide us either that protocol or at least a description of that protocol?
Protocol or description, yes, certainly.
Thank you. Can I turn to the next category of what your audit found? Did you find that despite the systems Uber had in place over a 2-week sample period, 37% of drivers had more than 12 hours of continuous driving time, with some cases up to 17 hours of continuous driving time?
Yeah, so what we were looking at in that audit, I mentioned before that we just what the obligations are on service providers. All service providers are expected to do what's reasonably practical around safety of drivers and passengers. They're required to have a safety management system. They're required to meet a number of specific requirements about the eligibility of drivers and the maintenance of vehicles. But we also hold that their safety management system should cover other things, and we made it clear to the industry that that includes things such as fatigue. One of the things we are looking for in these audits is, do they have a fatigue policy and an effective fatigue management system? What we found in this case is we looked at the fatigue management system. My auditors looked at the fatigue management system to determine whether or not it was effectively applying their policies. And our concerns at the end of it was, look, the general policy was that people should not spend more than 12 hours driving time, and that's appropriate and not consistent with most similar industries and elsewhere in this industry. But our concern was that the way the system was working was allowing people to not do more than 12 hours driving time logged onto the system and yet still spend more than that time on the road. And we were able to find that looking through other data that Uber had. So in our opinion, they should be able to find that too and make some controls over that. And certainly we found that there are some people driving more than 12 hours and in a few cases up to 16 or 17 hours.
Drivers in the point-to-point industry subject to the national fatigue law?
No, they're not subject to national fatigue laws, but they are subject to these laws, which require appropriate oversight. And that's one of the new things, by the way, under this legislation. So under the old laws, only the drivers had the obligation. Under the new law, we expect service providers to take responsibility for it.
Look, a chain of responsibility has been a governing process for a lot of transport law now going back nearly 2 decades. It's a very good thing. And for what it's worth, I accept that they're not subject to the national fatigue laws, but the national fatigue laws would make it clear that equally drivers have to take certain measures at 12 hours. I can't drive more than 12 hours without specific accreditation. So it's good that they're aligned. But this is pretty egregious. I mean, 37% of drivers in a 2-week period driving more than 12 hours a day. It's pretty alarming, don't you agree?
Well, what our view is, it's a matter that they need to fix, and we've issued them directions to fix it. And I guess part of the way it's worked is that, and our discussions with them was that their systems check whether a person has been driving for 12 hours for them, and then requires them after that to check out and not log in for 8 more hours. But
Well-
our view is that, this is one of those areas where technology is changing. I mean, going very much to the terms and reference in your committee. It may be that historically, when all these guidelines were established, people didn't switch around between providers. And it may be, but our view is that it's not a question of controlling fatigue only with the amount of driving within your system. But once you know someone has been driving for more than 12 hours, however, then we would expect some controls around that.
Well, Uber seems to disagree with your findings. They said publicly that they're disappointed they were not allowed to respond to the audit's findings before it was finalised. And they say that the audit contained some errors it planned to clarify with the Commission. So we'll take it step by step. Did you show Uber the audit before you finalised it?
We were in contact with them over a year, yes. And so they were, and we showed them the report, I think, a couple of weeks before we made anything public about it.
I just want to be clear, Commissioner, I'm not suggesting that you're under any obligation to do that, by the way. But I just want to just get as a matter of fact for you to give you an opportunity to respond to what they've said publicly. But your evidence is that you did show them to them a couple of weeks before.
We did, and we were in contact with them over a year about this matter.
Yeah. They then go and say that it contains errors it planned to clarify with the Commission. Have they identified the errors that they say you made?
They are discussing with my staff, but if they did not like the outcomes, they could, of course, have appealed it at any time. There are appeal mechanisms in place under this law. Of course, I'm, as a regulator, subject to appeal. They did not appeal. They've told us that they accept the directions they've been issued and are working to implement them.
Okay, well, on notice, can you identify what the errors they say you've made and give us any status report as to what your staff are up to in terms of their engagement?
If you're asking me what's the current...
Well, I mean, if there is any dialogue going on between the Commission and Uber since the audit, if you can just provide us on notice a description as to what that dialogue is and specifically identify what Uber says you got wrong.
Well, I think we can certainly give a description of what it is. Since Uber's accepted the directions, I'm not sure there is anything that at this point they're saying that we've got wrong, but I can certainly give you a description of...
I appreciate that. But they said publicly, for example, the driver fatigue finding is misrepresented, referring to continuous driving time when it actually includes the cumulative time a driver may be online, offline, and then online again throughout the day. Do you wish to respond to that?
Okay. Well, that's an issue that they raised at that point in time. I think, as I just mentioned, one of the concerns we have is that the obligation on service providers is not about not having more than 12 hours of driving time on their platform. It's about controlling fatigue.
Well, are you confident that today every rectification that Uber needs to do to ensure that their drivers, 37% of drivers, are not driving more than 12 hours continuous driving time are in place? Is this still happening?
We've directed them to do that, and my staff are working with them to make sure that happens, yes.
But can you give us an assurance that this practice has ended? Or are they in the process? What is the remediation that they have to do to stop drivers from driving more than 12 hours?
Okay, so the direction is to fix the problem. Okay, the direction is to take steps to rectify the problem. They can come up with a number of ways to do it, but we know of one effective way that is used elsewhere in the industry. So there's at least one effective way. And it's common practice elsewhere, including with other that simply to take the step that regardless of whether they've driven 12 hours for you continuously or 12 hours plus usually there's an expectation of a break in there. At some point after 12 or 13 hours since they first logged on, they are simply logged off, and it doesn't matter whether they've reported 12 hours on your platform or not. And that's well, you could see that as essentially the old concept of the shift moved into a information age, and that's a practice that others put in place to control this situation, and so we know there's at least one practice that they can put in place.
Well, have they put that practice in place?
Well, they've been directed to do it, and they're working on it now. Well, they are working on a fix.
How long do they have to do it?
We gave them several months to do it. We recognise that it may require changes to the coding changes to the driver app. So they will need time, a reasonable amount of time to do that.
But when? I mean, on notice, can you tell us when did you give them that direction and what date that they have to comply?
We gave them several months to comply with all the directions and then to do a final quality assurance on everything. So I could probably take a date on notice, yes.
Thank you. Why a driver, did you ever ascertain why drivers are driving more than 12 hours and some up to 17?
We didn't, well, we didn't interrogate individual drivers, if that's what you're asking, but our concern is, regardless of their reasons, we don't want a system that allows that to happen.
Sure, but we are inquiring into the reasons why that might be taking place. And hence we're wondering whether or not, do you have any view? I mean, this is not a one-off incident. It's 37% of drivers that are doing this. Like, it's more than 1 in 3. So do you have any inference as to why well, firstly, would you describe that as systemic?
I describe that as a problem with the effectiveness of that system, and they need to fix it.
Yes, but I'm asking you, would you describe it as systemic? If more than 1 in 3 drivers are breaching within a 2-week period, what should we infer from that?
Well, I think you should infer that it's not just a matter of one driver here. There is a issue, and we've told them this and directed them around it. There's an issue with your system, which is allowing drivers to drive for periods of time, which is a concern for us with regards to fatigue. And we think you need to fix the system, and it's not just a matter for an individual driver to fix.
Well, we've had other people come forward with evidence that says the reason why drivers breach fatigue in rideshare is because they're not paid properly and they're underpaid. And that effectively, in order to earn an effective economic income, they need to drive more. On the basis of what you've seen, it seems like we should agree with that.
Well, I mean, my view on this one is that, you know, the obligation is placed on the service provider to control the problem, and in a sense, doesn't matter. It is not an excuse for them to say the drivers do this or drivers do that. They need to take appropriate steps to control the problem at the service provider level.
But if drivers are needing to work this long in order to earn an income, they are likely to continue to try to work that long. Is that fair?
Well, there needs to be a system which, whatever the reason is, there needs to be a system that prevents it.
But are you looking into any of these reasons, or are you saying the obligation is purely on the platform?
Well, we aren't. If you're asking me about workplace arrangements, I think I said in my opening statement that we don't have any oversight of those. But I think there is a direct obligation. Yes, we would say there's a direct obligation on the platform to run an effective control system, and not just leave it up to individual drivers. Okay,
look, Commissioner, I'll just press one more time, and just to be fair, we have had multiple evidence from academics and others that say low pay to drivers results in drivers driving longer. Does the Commission have any evidence either to support that conclusion or to reject that conclusion?
We don't have any oversight of workplace arrangements. I'm not debating with the experts you've discussed with. I'm just saying that regardless of the reasons, there is an obligation on the service provider to take appropriate steps to control fatigue.
Okay, I'm going to pause there and invite questions from other committee members. There is the other matter that the safety audit surfaced, which we should, otherwise I would raise questions about, but I do want to pause for Mr. Mallard, Mr. Fang, or Mr. Searle, or Mr. Pearson, or anyone else to ask any questions if they so wish.
I'm fine, Mr. Chair. I've got no questions.
Mr. Mallard.
Yeah, good morning, Commissioner, and thank you for your submission and coming in online today to talk to us. I just want to do some background here. Your position was created by the state government as a response to the deregulation of the taxi industry and the arrival of rideshare services.
Yes, it was created in the new Pointtopoint Transport Act, which commenced in late 2017, and I was appointed on 1 July 2019.
So which act was that?
The Pointtopoint Transport Act.
Oh, yes, okay. Yeah, okay. And before you were appointed, and I guess before we had the sort of revolution of the deregulation of the point-to-point transport with the arrival of the platforms and Uber and others, how were was the industry, the earlier point-to-point transfer industry, regulated in the context of your work? You know, monitoring, complaints, compliance, and so forth. How did it work before?
So prior to the new Act, and in those days the regulator was the then Roads and Maritime Services, there were obligations on drivers, safety obligations around drivers and owners and operators of vehicles, and they had a series of safety obligations. What has changed is that the new laws place obligations directly on the people at the top of the tree, service providers. One of the issues with the old laws was sometimes there are things which are much better controlled by service providers than by drivers. And fatigue that we just discussed is an exact example of one of those. So what the old laws didn't do and the new laws do is actually apply obligations to the people at the top, the service providers themselves. So the kinds of audits that we're currently doing on service providers could not really occur under the old laws.
So, I mean, I recall in our days, and as a council in the city, and always get complaints from taxi drivers themselves about the inspectors at the ranks, about the targeting of the actual individual who might be driving or operating the vehicle at the time for complaints and getting fined and so on. Is that the way it used to be? And we've moved it under the new Act to really focusing on the big bosses, the service providers.
Yes, well, we still have on-street compliance teams. I still have inspectors at the ranks now. They're often in the rideshare waiting areas as well, the holding areas. You know, they're out on the street. But on top of that, we also now are looking, as you say, at the big bosses. Yes.
So from the earlier days, we were pretty much dominated by the taxi industry, or was dominated just by a monopoly of taxis, to where we've got this deregulated situation today. Has the participation in rideshare, the operators, has that grown exponentially over the last, what that would be, over the last decade?
We've certainly seen an increase in service providers in recent years, in the number of service providers, in the amount of customer choice as a result. Those both an increase in booking service providers and taxi service providers, by the way, and a dramatic increase in the number of trips that people are taking. It was pre-COVID, it had risen to about 75 million trips per year, which was up from perhaps somewhere in the 55 million or so beforehand. And we've also seen, and Transport for New South Wales does this, they do customer satisfaction surveys across most transport, public transport and taxi, rideshare and hire car modes. And we've seen quite a steep increase in customer satisfaction for all modes, rideshare and taxi. So we're seeing quite an increase in what customers can use and do use and their satisfaction with it. In terms of as I said, now there are approximately 2,000 service providers in this industry, and they range from very large providers such as Uber and 13 Cabs, through to regional taxi companies, through to a large number of small providers who may have one vehicle and, for example, be running a hire car or a tourist service somewhere, or they might be running a wedding car. There's a very wide range of people in this industry.
So consumers, therefore, are actually consuming more of these rideshare services than historically. So we're actually getting, a taxi or an Uber to dinner and things like that more than we used to.
Yeah, there's just there has been a significant increase in the number of trips people.
Probably related to lack of parking and congestion on the roads. So the reason why I do it. That's interesting. Have you got any sort of historical data on that you can compare back to before the Act around things like, my colleague Mr. Mookie seemed to be focused on the regrettable sexual assaults, and I know they happen. They've always happened. They shouldn't happen, but that's part of the danger of this whole process. And other issues of complaint, or even fatigue. We talked about fatigue. Can you give us a historical perspective? I mean, we talked about 12 assaults not reported, alleged assaults not reported. Can you put that in a context of historical situation at all?
You'll appreciate that. Obviously, any historical data will tend to be taxi focused, but
Yeah.
the new laws are the same for everyone. You know, they have moved from being only placing obligations on drivers and the owners and operators of vehicles to placing obligations on service providers. The Bureau of Criminal Statistics, yes, thank you, has published historical data on taxis, which goes back, but also up till now, and there's been a fall in assaults under the recent laws and under our time administering the laws. As I say, that represents a period when obligations have started being put directly on service providers to run a safe system.
Fall in
Now,
real
can I
numbers.
Yes.
And then because there's more providers, pro rata or fall too. Yeah. Okay. Well, thank you for that, Mr. Hawking.
I was just going to ask to supplement that data request, Mr. Mallard, by going, if you can provide that broken down by ride booking service providers, taxi service providers, that would be useful since the new laws commenced.
Oh, you mean the Boxar data?
No, the notifiable incidents nature that you've received relating to, in fact, all the notifiable, like just the number by year of notifiable incidents by booking service provider as a whole, and I guess taxi service providers since your commencement. Is that possible?
Oh, okay.
Well, the different categories, you mean, not the companies.
Yeah.
Just BSPs versus, sorry, just booking service providers total versus taxi service providers total. Yes.
Yes. Equally, just in terms of data requests, while I've got you here, Commissioner, can we also get the number of drivers that are registered to provide services through booking service providers and as well as taxi service providers? Do you have that data?
Well, what we know is the number of drivers who've applied for a PT code on their license, which means that they meet the commercial medical standards. That's approximately.
Sorry, go ahead, Commissioner.
I was going to say that's approximately 130,000 at the moment. Approximately 130,000. Obviously, they're not all driving at any time, and in fact, very many were not driving during COVID. But that's the number who have the license code, which shows that they meet the commercial medical standards.
Are you able to provide us, firstly, the trend data on that as to how many in each of the years since the creation of your office of people who have that PT code?
Trend data on the PT code year by year. Yes, of course.
And then equally, if you do have any information about active versus inactive over the same period, that would be really useful as well.
I don't think we would have that, but I'll include it as part of that.
Okay, and then whether or not you can, from any of your audits or otherwise, discern the numbers that are providing services through Uber, Didi, Ola, taxis would be useful, because obviously those companies keep that information commercial in confidence, or even if you can't do it at the level of the platform, at least the numbers that are in rideshare versus the numbers in taxis, that would be useful.
I'm not sure that's a meaningful number because people can and do drive for both taxi platforms.
We are just eager for whatever demographic analysis you can provide us on the workforce in the industry. And then do you have numbers of cars that are eligible to be used in rideshare?
To be eligible to be used in rideshare, they would have to meet certain vehicle maintenance standards, but they do not require a specific number plate or license code. So I don't think I would have the
But they do require a specific CTP policy or disclosure for the purposes of CTP, do they not?
They would require the appropriate CTP. If there are detailed questions about that, I would probably have to refer those to CIRA. Could
you, if we could find out a number of cars in New South Wales that have the specific rideshare CTP disclosure, that's a useful proxy over time as well. And then we'll go to Mr. Pearson.
Sorry, I know it's just closing now, Mr. Wing, Commissioner. Just a quick question, and you can take on notice. Has it been considered at all for there to be surveillance devices installed for the time Uber drivers or other drivers are using their vehicle in relation to looking at the issue of safety and security?
Cameras.
Yeah, so cameras.
Okay. All safety measures are considered from time to time, and technology, the change in technology is one which could really affect the camera question. There's no doubt about that. So I'm happy to take it on notice, but I will say that yes, we have we do from time to time consider whether the advances in technology mean that cameras may be feasible in future.
It certainly made a big difference in the taxi industry when it became virtually mandatory. Okay, thank you very much.
Thank you, Commissioner, for your time with us this morning. You have taken a number of questions on notice for which you'll have 21 days from the date of receipt of the transcript to provide us with an answer. The Secretariat will also forward you all the questions you've taken on notice as well. But we again appreciate your time with us this morning. We will now, you are excused, and we will now go on to break, and we'll resume at 11 o'clock with the tax commissioners.
Thank you.
I encourage members to turn off their videos and their cameras whilst we are still broadcasting.
Good morning, Mr. Johnston, Mr. Smythe. This is Helen from the Secretariat. Can you hear me?
Good morning, Helen.
Morning. Could I just do a quick audio check with both of you? So, Mr. Johnston,
Yes, good morning, Helen. Hope you had a nice weekend.
thank you. I did, thank you. And Mr. Smythe, Mr. Smythe, could you just say something? We can't hear you. You might be on mute. No, we're not getting anything.
Oh.
Yes, we just got something.
hear?
Yeah,
Yes,
oh
we
no,
can
we
hear.
can hear now.
Can't hear you either.
Can you hear us?
Yeah. Can you hear me yet?
Yes.
Yes, we can hear you.
Are you hearing me clearly?
Yes. Okay.
It was the unplug and replug seemed to cure the.
Great. Well, we are just on a break until 11, but it is still being live streamed. So I just ask for you both to put your mics on mute until the chair recommences the session. Thank you.
Okay. Thanks, Helen.
We welcome our next set of witnesses, the Chief Commissioner for Taxation in New South Wales, as well as the Commissioner for State Revenue. Thank you for taking the time to join with us this morning. As both witnesses are previously sworn, there's no need for you to take your oath again. You are under your previous oath. Is that clear? Great.
Yes, Mr. Lucky. Good morning.
Thank you. Good morning to you, Mr. Commissioner Johnson. Can I invite either the Chief Commissioner or the Commissioner to make a short opening statement if you so wish?
Yes, I'll make a short statement. Thank you to the Select Committee for the invitation to reappear at this hearing to give further evidence. By way of opening statement, I'll just reiterate the responsibility of Revenue New South Wales and make a few observations. Firstly, Revenue New South Wales' responsibility for administering the state's taxation laws. We administer those laws fairly and impartially. And whilst we assist the government in reviewing those laws and developing any changes, we're ultimately not responsible for tax policy. Tax policy is led by the Treasurer and his department, and therefore we will not make comment on policy questions. Hence, to the extent that the Select Committee is investigating possible legislative changes to address issues raised during the inquiry, we're not in a position to make comment. Secondly, I'd like to outline how the Payroll Tax Act 2007 may relate to the gig economy. Basically, under the Act, wages or payments paid by the employer to workers will generally be taxable if the workers are common law employees or the workers through independent contractors are nonetheless in an employment-like relationship with the employer. In relation to independent contractors, the Act makes wages paid to such workers liable to payroll tax unless one or more exemptions apply. These exemptions generally relate to circumstances which suggest a non-employment-like relationship, such as where the contractor's services for the employer are of a limited or transient nature or incidental to the activities of the business. The kinds of employment models used by businesses in the gig economy may attract the contracted provisions in the Payroll Tax Act, or indeed the general employer-employee provisions. This means the wages gig employers pay their workers may be liable for payroll tax. Determining payroll tax liability will require consideration of a range of factual circumstances that go to the overall character of the worker-employer relationship. Based on those circumstances, if the relationship is one of employer and employee, one of principal and contractor and no exemption applies, then subject to the total wages exceeding the payroll tax threshold, the businesses will be liable to pay payroll tax. The fact that a business enters into contracts with his or her workforce and refers to the workers as contractors will in no way be determinative of the issue. It's the substance and totality of the relationship that matters. So we at Revenue New South Wales understand that determining whether payroll tax liability exists for these types of relationships in the gig economy may be difficult and complex. And on our website, we've made available 11 revenue rulings dealing with determining the employer-employee relationship and the contractor provisions and the exemptions that might apply. We've also issued a Commissioner's Practice Note dedicated to the contractor provisions, providing more examples and easy to follow diagrams of when exemptions would apply and the records employers are recommended to keep justifying those exemptions. Finally, we've also issued videos on our website dealing with topics such as the contractor provisions and more generally the application of payroll tax in New South Wales. If any employer is ever in doubt about their payroll tax obligations, they can always ring Revenue New South Wales and speak to one of our experienced staff. Therefore, we've provided a significant amount of guidance to assist taxpayers in navigating the contractor provisions and generally complying with their payroll tax obligations. I'd finally like to say something briefly about our approach in applying all legislation we administer. Our approach is to encourage and assist clients to comply with the law by providing information, education and tools to help them understand their obligations and the grants to which they're entitled. Treat all taxpayers fairly by applying legislation in a harmonised manner to ensure a level playing field, and detect and deter non-compliance by concentrating on areas of high risk. In respect of compliance, our risk-based approach is designed to focus activities on areas of highest potential for non-compliance, use data analytics and risk assessment processes to identify taxpayers who may be non-compliant, and specialist analytical software to review taxpayer data that we've obtained from a number of sources. The question of whether a person is a contractor or an employee is an area of compliance risk across many industries, including gig businesses. And it's also one that businesses can often get wrong. Gig economy businesses view their workers as independent contractors and are not paying payroll tax and the payments made to them. Recent decisions in Australia and overseas have been a mix of employee and independent contractor determinations, which makes our compliance audits complex. And the agreements under which gig economy businesses engage workers are constantly changing. Agreements for engaging workers differ from businesses operating in the gig economy, meaning each separate arrangement needs to be examined to determine if there is a payroll tax liability. Chair, that concludes my opening statement.
Thank you, Chief Commissioner, and thank you equally for the thoroughness of it as well. We will commence questioning. I should just flag at the outset, Chief Commissioner and Commissioner, that we have invited you for 2 hours, but it's unlikely that we're going to require all that time in the format that we're in. It just may be particularly as I know I and others intended to ask you questions about certain documents, but it's just not practical to do it in the current format. So I just want to flag that and just say at the outset that should we end earlier, we mean no offence, and we do appreciate the time that you've taken on a second occasion to make yourselves available to the committee as well, just to be upfront and clear with you.
I'm sure no offence will be taken if we finish early, Mr. Moogie.
Indeed, you maybe enjoy your freedom. It's the season. Can I ask you, Chief Commissioner, to provide us with an update as to where you are in terms of the certain investigations that you're making reference to at your last hearing? Subject, of course, I know, to your constant refrain that you are limited by the statutory secrecy provisions of the Tax Administration Act as well. So I'll ask you an open-ended question to allow you to formulate the response that you think you can give us about where the status of those investigations are up to.
Okay, thank you, Mr. Mookie. We took at the previous hearing on notice the number of entities that we've been investigating. So, and the response that we provided, I think it was early July, was that we were currently auditing 13 entities. that remains the number that we're still working through. We've completed 9, and we've got an additional 13 that we're auditing. Now, we have had a reduced focus on compliance and auditing over the past several months, as you could imagine, due to a range of things happening and other supports we're providing through COVID, but also working with the businesses around their ability to provide the right kind of input to these functions. So they remain ongoing, but progress for the last 4 months or so has been slower than planned.
So just to be clear, you've completed 9 audits or investigations. Is that clear?
That's
In
correct.
relation to the company or subject matter of our terms of reference?
Sorry, I was referring more broadly to businesses that might be referred to as a gig economy business. So you named a list of businesses, which many of those are included amongst that group. But we don't define our audit program by the businesses in the standing order 52. We have a look at the risk-based framework that we have and approach our work accordingly.
Well, if you're ever tempted to adopt our SR52 framework as the basis of your audit program, you let us know for sure. I'm glad we could be of some assistance. But just to be clear, we've completed 9 audits, and you have commenced since 13 additional.
There were 13 in train before.
Okay.
There are currently 13 in train, and they have been for a period of time. And my response to the question on notice back previously quoted that same number.
Okay. Of those 9, have any of them led to the issuances of any additional notices of assessments for payroll, unpaid payroll tax?
I would have to take that on notice just to be clear in terms of where they were based on the timing of my response. But there has been issues of assessment.
Yes.
Provided
Well,
on
I'll go straight
on many
away
of
to a matter which has surfaced in the public domain since we last had the opportunity to discuss, because I think it's just pertinent to what we're doing. And I think that is it the case that in February this year you issued additional notices of assessment to companies trading as Uber?
So we have completed that audit, and yes, we have provided notices of assessment. The matter is continuing in discussions with that business.
Because Chief Commissioner, I am conscious of your statutory secrecy provisions, albeit I don't concede that you are. I certainly formally do not concede that would inhibit your ability to answer. But in order to perhaps allow this questioning to go place in a way which doesn't trigger a dispute, I'm just going to refer to what is on the public domain, which is an ABC story from 8th of September 2021. So you can just understand that's where questions are being sourced from. So you can provide your response accordingly. Is it the case that you issued notices of assessment to Uber totaling $81.5 million of unpaid payroll tax?
So that we have issued a notice of assessment. I'm aware of that article that you've mentioned. I couldn't speak specifically to the value of that assessment, but it's a significant amount.
I'll just read it to you, and you tell me whether you think this is factually wrong. This is what the ABC reports. They reveal that on September 12, 2018, Revenue New South Wales issued a payroll tax audit against the company, and in February this year issued tax bills against the company totaling $81.5 million. This is for amounts the state considers Uber owes through 30 June 2020, and the accounts note that the group has filed an objection. So is that accurate?
I don't have the assessment in front of me, but that would be broadly accurate with. I would assume that I have no reason to believe that's not accurate. That amount.
Sure.
And,
it says
and more. Sorry,
Chief Commissioner, you go.
I was just more to the point of, rather than being bogged down into the value, which I don't have necessarily in front of me, and have some concern about sharing. The point being, we have provided an assessment.
Okay.
To Uber.
Sure.
that many of the facts in that article appear correct from a Revenue New South Wales perspective.
Thank you. And look, just to be abundantly clear, I believe the ABC has sourced this from documents that Uber itself has filed publicly. It's disclosed in their accounts. So just to be clear about that. The report then goes on to say that Uber has triggered the appeal process in respect to that. Are you in a position to provide us with any evidence or any about where that appeal process is up to?
It's not other than it's continuing to progress.
Yeah, and just step me through under the Act what the appeal process is.
Mr. Commissioner Smythe, do you want to step through the...
Commissioner Smythe is on mute.
We can't hear you.
Commissioner Smythe might need to unplug again.
Now,
I have a suspicion, Commissioner Smythe, unless you tell your software that that's where you're getting your microphone from, it won't pick it up, for what it's worth. Tech support, we're here to help. Commissioner Smythe, I think we can hear you now.
how is that?
Yes, thank you.
Okay, apologies for that. I'm going to try and move as little as possible and not impact the microphone. So the process is once a notice of assessment is issued to someone, people generally have 60 days to make an objection. They will come back to us and object. The objection is considered independently of the initial assessment, so it goes to a different part of Revenue New South Wales, where experts or technical experts will review the information provided, listen to any or understand any arguments that may have been provided, and then we'll make a further decision. Once that decision is made, a letter determining the objection is issued. The next steps for a party who's dissatisfied with an objection, and sorry, an objection may be allowed in whole or in part, or disallowed in whole or in part. Where a taxpayer is unhappy with the results of that objection, they have the opportunity to progress the matter either to the tribunal or take the matter to the Supreme Court.
Okay, so in respect to these particular notices of assessment, are we at the point where any matter has been lodged with the tribunal or the Supreme Court?
I'm not aware of.
So, you're not aware? I'm sorry, Commissioner Smythe, you're coming in and out now.
We are not aware. Sorry, I personally am not aware of the current status of any objection in relation to that.
Okay. Can you on notice provide us the latest information you have about the status of this particular dispute, especially if it's now surfacing in tribunals and or Supreme Court matters?
Yes.
Thank you very much. But Commissioner, as a long-standing fan of Revenue New South Wales compliance, I mean, in an ordinary year, you would collect 135 million-ish through your payroll compliance team. Is that about right?
It would be more than that, actually.
So 200? Sorry,
Yeah.
My ability to keep track of your compliance collections by tax might not be as good as yours, Chief Commissioner. Forgive me.
I think that's perfectly reasonable. So I'm just trying to navigate, also get used to this new way of working. It's in excess of 200 million a year.
Sure.
Yeah.
And this is an 81.5 million bill, which I presume covers 2 tax years, given that the audit commenced 2018. Is that fair?
So we've identified, sorry, just to answer the previous question accurately, 251
Wasn't too
million
far off.
in the last financial year, our compliance efforts.
Yeah. Okay. So
Actually-
I'm not too far off.
No.
Okay. But bear in mind, I mean, if this audit covers 2 years, which is 2018-19 and 2019-20, if it's issued and resulted in an $81.5 million assessment over 2 years, I can infer, although this is not exact, but let's just be conservative here, it's 50-50 per year. although it could be higher in some years or lower than the next. But is that, assuming it's 40 million per year, that is 20% of your compliance activities arising from one audit. Is this the biggest variation to the payroll tax assessments you've issued as a result of an audit in the last 5 years?
That's a very good question, Mr. Mookie, which I couldn't answer on the spot here, but it is a significant.
Have you ever issued a notice of assessment for more than this as a result of an audit? Commissioner Smart?
Can you hear me?
Yes.
Yes.
Apologies, I was trying to answer. The first thing we would need to take on notice, I don't have the details here at the moment as to whether or not the assessment that you're referring to was in fact just for 2 years.
Sure.
So under our legislation, we generally will, when we're undertaking audit activity, we will look back up to 5 years.
Sure.
But one of the interesting things with payroll tax is the position that a particular taxpayer or group may find themselves in 1 year may change from year to year, depending on a change in the arrangements or contractual relationships with,
I agree with you.
particularly with contractors.
But look, Commissioner, I agree with those caveats, but let's even accept that it's 81.5 over 15 over 5 years, which is, I think, the statute of limitations or thereabouts, I think.
That's right.
That's still a lot of money per year. That's more than 15 million per year. So it's either close to 10% of your annual collections, even if you want to use the conservative scenario. Would you agree that this is a pretty big correction for a taxpayer to receive?
Yes, absolutely. Yes,
Yeah.
absolutely. It is a significant assessment and a very large correction as you described. Whether it's our largest, I couldn't speak to often.
If you could on notice, that would be helpful. But can you be clear, is this just the rideshare component of Uber's activities, or does it cover Uber Eats as well?
Take that on notice.
Okay. I'm going to infer that the reason why you issued this assessment or this correction, well, it's an amended notice of assessment. Can we term it that?
Yes.
Yes. Is because as a result of your audit, you concluded that under the New South Wales payroll tax, is it the case that Uber underreported its head office staff or its direct employees, or is it the case that you considered their driver partners or drivers to be either contractors or employees for the purposes of the Payroll Tax Act?
Mr. Mookie, I assure you I'm not trying to be evasive, but when we begin by looking into the specifics of a particular audit, it's quite a number of factors taken into it.
Sorry, Commissioner Smythe, your audio is soft and intermittent.
There's a number of items that are taken into account with any given. It's because it's an operational matter. That's not information that the Chief Commissioner or myself would have.
Okay, look, I don't understand.
So I'll to paraphrase Commissioner Smythe, there are a range of issues why an assessment will be arrived at, and much of that, even though scale is significant, it is our technical experts in the operation and an operational consideration to how do we land on that. So we couldn't speak of the reason why the assessment landed.
Well, can I just put it to you? You considered them to be contractors or employees for the purposes of the payroll tax. They're drivers.
Again, I appreciate this probably does feel like we're being evasive, but I'll confirm that on notice.
I believe that would be a fair assumption, subject to confirmation.
Okay, so we can proceed on the next set of questions on the basis that that's a conclusion that you reached.
Which we will confirm.
Yes, thank you. Well, I'm going to leave it. Well, I'm going to pass to my colleagues very shortly, but that actually gets to the core of the terms of reference we have as an inquiry about the effectiveness of payroll tax. about whether the statute allows you, it provides sufficient clarity. Now, I accept that you can't, you've made your point that you're not here to provide policy commentary about future intentions of the Parliament or the government. But as it applies so far, was it a simple conclusion for Revenue New South Wales to reach under the existing payroll tax provisions, or was it difficult?
So I would say, speaking broadly, and Commissioner Smythe might want to answer more specifically, this is a very complex area of compliance for Revenue New South Wales, in part because of the emerging businesses, the emerging business models that are worked through, and we're dealing with different aspects of industry that we mightn't have done previously. So did the legislation enable us to come to a conclusion? Well, yes, I think we have evidence to show that it is, that we are providing notices of assessment. But it's complicated. And it takes time, and the point of looking at all the factors in totality mean it needs some strong consideration, and both parties, the businesses involved, have to engage with us and have a perspective of their arrangements and their appropriateness to pay payroll tax.
And is it the case that the complexities added to by each taxpayer changing their arrangements year to year as well? It's not just new platforms arriving with new business models, but each platform also changes its business model relatively frequently. Would you agree?
Yes, it's not static, and so one year's assessment may be different to the following years.
Indeed.
Because of the business model's changing.
Yeah, I'm going to pass to my colleagues now, Mr. Searle.
Mr. Mookie, apologies if I could just add one thing.
Sure, Commissioner.
In support of the Chief Commissioner, the challenges that we face here in New South Wales not only are the same challenges faced by all of the other jurisdictions around the country, but as I know you're aware, similar challenges are faced right around the world. Regulators trying to deal with these rapidly changing business. Fair work decisions in the United Kingdom, similar issues around in California.
I'm really disappointed, Commissioner Smythe, but you're coming in intermittently. I'm just going to have to either ask you to, it's going to be very difficult for Hansard to record your answer. And so I don't know whether you are in a position to change your microphone or not, but it's just we're hearing every second word. You know, it's just not fair for Hansard. Maybe on notice, can you provide us with the additional detail that you wish to refer to there? Great, thank you. Mr. Smythe has verbally indicated yes in the absence of his audio working properly. We'll go to Mr. Searle.
Yes, look, thanks, Commissioners, for coming along and giving evidence today. Having listened to your opening statement and looking at Revenue New South Wales' submission, there seems to be a level of complexity around, whether payroll tax is payable vis-a-vis, is someone a common law employee, is it a contract for service? There's all of these sort of different tests which can be quite complex, and like Mr. Mookie and others, I'd be aware of the difficulties arising from the VABU line of cases and those sorts of issues. Would it be simpler if the legislation simply applied to workers as opposed to employees and various other things of that nature? With that sort of reducing the complexity, making the task of applying legislation a much more straightforward affair, would that assist your organisation with effectiveness, do you think?
Mr. Smythe, if we can hear you.
Can you hear me now?
We can.
Yes, much clearer.
Right. Mr. Searle, with respect, I think that was it's a very good question. One of the difficulties, though, is this of course moves into a policy area that is that goes beyond the remit of Revenue New South Wales as a mere regulator. The only point I would make in relation to that is, to an extent, principles-based and simplifying legislation can act somewhat as a double-edged sword. So while it simplifies the administration from our perspective, it very well may carry consequences that do not exist under the current legislation. For example, capturing genuine independent contractors in circumstances where, from a policy perspective, it may not be the intention to levy tax upon them.
Okay. But excluding, I mean, I guess the test of whether someone's in business on their own account is not always straightforward, but, you know, there are indicators, you know, do they have letterhead? Do they have business cards? Do they provide their own work equipment? All that sort of thing. But again, leaving those considerations aside, simplicity would definitely assist, you know, any sort of tax collecting agency with its role. You would agree with that general proposition?
So I think sorry, Commissioner Smythe was also about to speak. I think simplicity always is easier to administer, but does it achieve its policy intent? It can become more challenging, or potentially unintended consequences might arise, which is what Commissioner Smythe was trying to speak to. And so I would suggest, while this is a very fast evolving and complex area for us to navigate through, using the common law provisions that we are and following the development of case law enables us to effectively administer the legislation. But it remains complex and does take some time.
Okay. Could I ask this question then? And I think this is touched on in your submission. Do you have any data or any sort of strong appreciation of how many, and I use the term workers sort of to cover, you know, everybody in respect of whom you collect payroll tax, how many of that, you know, how many workers are covered by the current payroll tax regime, and how many of those are employees and how many are other kinds of workers? Do you have a sense of that?
If I may, Chief Commissioner, Mr. Searle, I don't believe that is a level of data that we do collect. One of the issues around that being the types of payments that can be subject to payroll tax can at times include payments to directors, for example. So it's quite it's not something that, to the best of my knowledge, we have a level of detail that we have previously collected.
But there is, what, 52,000 businesses New South Wales registered for payroll tax on an annual basis or thereabouts?
Yes, that's correct.
That's out of a pool of generally 750,000 businesses in New South Wales, according to other figures.
That sounds about right.
And we know how much the wages are covered because that's how much we collect. That's fair?
Yes.
But you would have some data on employees. I mean, having read a lot of your reports, Mr. Searle's question, you do have some data. You might not have it in aggregate form, but you would have.
We do. We have access to significant data from other jurisdictions, including the ATO. And we utilise that for our assessments of and our compliance program. I think both of us took the question from Mr. Searle as an aggregate view, and it's not something that we'd have probably naturally.
Well, are we taxing our friendship if we were to ask you to, on notice, provide some top level numbers?
We can have I'll happy to take that on notice and see what we can do to provide support to the community.
Well, thank you for that, because in terms of payments to directors, I mean, obviously, some directors are what you might call working directors. They're, you know, for want of a better phrase, they're working in the business. They're, to all intents and purposes, an employee of the business. So it's not inappropriate that you'd be collecting payroll tax in respect of those workers in that situation. So yes, taking Mr. Mookie's suggestion, if you could interrogate the data you've got to provide us on notice some answers, that would be very useful.
Yes,
thank you, Mr. Chair. Those are my questions.
Mr. Fang?
Chair, I've got no questions at this time.
Okay, so I have a couple more about this matter, and then I think we would want to ask you about the passenger service levy and where you are in that in terms of that compliance and collection efforts too. Just returning back to the other matters, you are still in liaison, are you not, with the ATO about enforcement on companies that are loosely described as gig related?
Sorry, it just broke up fractionally there, Mr. Mookie. Could you just ask that question?
You remain a part of the task force or with the Australian Taxation Office that might be looking into these matters to do with gig companies?
Yes, we continue to. Well, we work nationally across with all jurisdictions around these matters and share information.
And you, incidentally, I presume you last time you made reference that you share with other your state counterpart bodies. That's correct?
That's correct. So
can you provide us an update as to whether or not you shared the result of your decision to issue the Uber-related group of companies with a notice of assessment with those other jurisdictions?
I would have to take that on notice, unless Commissioner Smythe has a response. I'm not sure.
Not as a specific, but our general practice. So in relation to your specifics, Mr. Mookie, yes, we take that on notice. Our general practice is we try to liaise and stay in very close contact with all of the other state revenue authorities, with a view that where there is a business operating in more than one jurisdiction, we make sure that we keep each other apprised of what the approach is from a payroll tax decision. This often bears fruit when we're dealing with multi-jurisdictional audits. Often there may be an audit in one state that is concluded. The results are then passed on to the other jurisdictions to make a determination on whether or not the same results should follow in those other jurisdictions.
Well, that's useful context as well, but I'm specifically referring to the parts of this ABC story that reports on certain tax structures and transfer structures that have been adopted within the Uber group of companies, which basically means they're routing all their revenue through the Netherlands. Has that had any bearing or impact on the ability of you to collect any revenue that might be owed to us or not?
If I might, in a payroll tax context, that is, while the use of international vehicles may have some impact from a grouping perspective, it's less of an issue broadly for gig operators, and it's because we look at the receipt. I mean, being honest, it depends on the way the structures are being used.
So what I'm specifically asking, I guess, is that at various points in the past, drivers have been contracted directly with the Netherlands outfit, and I think that's changed, to be fair, as well. But it may have been covered, particularly if you were looking over the 5-year period of time. And I'm wondering whether or not, as a result of the decision to both engage drivers with the Netherlands outfit, particularly when Uber was setting up, that may have resulted in an under-declaration of wages, or equally a incorrect assessment as to their status. Are you able to shed any light on that?
I think that's, to the extent that we would have any knowledge of that, that is something that we would need to take on notice.
Okay.
I can say I'm not aware of any international aspects related to payroll tax in recent times having a negative impact on our ability to collect.
If people who are providing employee or contractor like services in New South Wales through an internationally registered outfit, be it a company in the Netherlands or elsewhere, what impact does that have on your investigation powers and your collection powers?
It's a great question, and I'll try and keep this brief because it is an area that I find quite fascinating from a tax perspective more generally. You can tell from the look on the Chief Commissioner's face that he's no doubt worried I'll launch into into a technical aside, but the answer really comes down to the willingness of organisations to engage with us. So there are a number of tools under the Taxation Administration Act for us to require or request information from international entities. But at the same time, due to our ability to share information with the ATO and other regulators, there are a number of other tools available to us if entities were to be less than forthcoming.
Well, are those tools in the Tax Administration Act fit for purpose, or is there a suite of additional tools that exist in other jurisdictions in Australia or elsewhere that might be of assistance that we should consider recommending be put into the Tax Administration Act?
I believe that the tools we have at the moment are good. They are constantly, we're constantly reviewing them, as we are constantly reviewing the powers that are exercised by authorities both within Australia and overseas. There are some issues with attempting to enforce tax debts or to chase to try and obtain additional information from jurisdictions overseas. While I've dealt with those in many cases, viewing court decisions, for example, it is not something that I've had to deal with directly in recent years.
Chief Commissioner, do you wish to add anything to that?
No, I think that was a fair response. I think there's nothing clearly obvious for us to suggest that from experience with other jurisdictions that will make a fundamental difference to what we're trying to do.
Okay. On notice, if you wish to provide any further detail, that please do, of course. Can I now ask, just we've had other witnesses come to our inquiry in which we've asked them questions about their payroll tax status, for which they've made various claims. I will just put them to you with a view to give you the opportunity to respond or otherwise, but we've had companies like Deliverers say that they are in compliance with all their obligations. Have you completed your audit and investigation into them?
Just one moment, Mr. Mookie. So this is another business we've issued assessments to. Our investigation's concluded with Deliveroo. So the substance of the assessment, I'm not across for this discussion, but
and I'm sure if you were, you wouldn't tell me anyway, Chief Commissioner. So
I'd be very cautious to what as you expect.
Okay, but you have completed it.
Yes.
Okay. Equally, what about Ola? Have you completed your investigation into them, or have you had an investigation into them?
I would have to take that on notice regards to Ola.
Okay, and DoorDash?
There's we haven't issued an assessment to DoorDash from compliance activity. I can share that, but as I said, our last year or so of compliance activity has been quite fractured due to COVID and the changes that we've had to apply to payroll tax to provide support to businesses. So I think going through a list of businesses, many of them I won't speak to specifically, other than we continue to look at businesses engaged in the gig economy.
Yeah, I accept that the detail that you might not go into, but I'm just, given we have asked them questions, I just thought that we should at least give you the opportunity to comment on their reply if you so wish. The only other
no comment to that business.
Yeah. The only other two which I should put to you and give you that opportunity is in respect to Hungry Panda and Easy.
Similarly, I think because we do have a significant, again, speaking in the abstract, we've for us some significant audits underway in this space. I think it's appropriate. I don't speak to where we're progressing.
And look, again, I just have to, you might wish to make the same answer, Chief Commissioner, but the other one I forgot to put to you is menu log.
Similarly, this is a business which was part of the standing order where we're working with that business currently through a process.
Sure. I'm going to pause there and allow Mr. Mallard any questions that he might have before we go on to the passenger. I intend to ask you about the passenger service levy compliance. Mr. Mallard, are you okay?
Mr. Chair, thank you. I'm fine. Continue.
Okay. Chief Commissioner or Commissioner, can you describe how you audit for compliance with the passenger service levy?
So the passenger service levy, we actually we don't conduct the compliance effort for that. That falls to the Point-to-Point Transport Commissioner. Our function for this is the collection of the levy via direct debit, customer bank accounts, and debt recovery. So we have a very limited function in this space.
Okay, so have you had to have any debt recovery actions in respect to that levy?
I'd have to take that on notice to the specifics. I was more prepared for payroll tax discussions today. So.
To be fair, Mr. Shoebridge was asking these questions this morning, so I felt that if we have you here, we should put them to you too. Are you in a position to tell us how much you have collected in the last 3 months?
I'd have to take that on notice.
Fair enough. And equally, we heard about an underpayment by GM Cabs. Have you recovered that money or collected that money?
I would have to take that on notice as well to respond.
Okay. And do you maintain forecasts of collection for the next year?
We would, yes. What that is, I haven't got that in front of me.
Can you take that on notice?
Yes.
That's fair enough. Committee members, do you have questions? Any further questions?
No, thanks, Chair. I'm good.
Great. Well, on that basis, Commissioners, as we flagged, we might let you go earlier than intended. Again, we really do appreciate you putting the time aside and making yourselves available in this format as well. And you have taken multiple questions on notice for which you'll have 21 days to provide an answer after the date of receipt as well. And if you get any supplementary questions, you'll equally have 21 days. We very much appreciate your time in both sets of hearings. You are excused. Thank you very much. We will call an end to the public hearings then, and then have a very, very short deliberative, members.
Thank you, Chair. Thanks, Committee.
Chair.